Well, let's now take you to some of the journey as to where it all started. We begin with March 11, 2019. Emeka Ihedioha of the PDP was declared winner on that date. Now, January 14, 2020, the Supreme Court nullified the election of Emeka Ihedioha as governor of the state and declaring Hope Uzodinma of the APC as the winner. January 17, 2020, leaders of the People's Democratic Party resolved to stage a protest across the streets of Abuja. We all saw that. This was over that verdict of the Supreme Court. January, that's the same month, but the 29th this time, the Imo Speaker, other lawmakers in the Imo House of Assembly defected to the APC barely 3 weeks after the Supreme Court sacked Mr. Ihedioha of the PDP. January the 31st, PDP protested in reaction to the Supreme Court judgment on the Imo election. They submitted protest letters as well to some of the embassies. February the 1st, 2020, Imo PDP protested on the Supreme Court judgment as well. February the 7th, the Imo APC, on the other hand, protested the same verdict in support. Ihedioha fighting back as the matter be reviewed. On the 13th of February, Imo lawmakers passed a vote of confidence on the judiciary and the Supreme Court. Also that date, some lawmakers from Imo State under the party, the AA, defected to the All Progressives Congress in the House of Representatives now. On the 18th of February, the PDP and its candidate, Mr. Ihedioha, requested 7 days from the Supreme Court. This is to regularize their processes. Court adjourned to March the 2nd for ruling. And we heard the 27th of February, Imo PDP held a prayer ahead of the Supreme Court judgment. And of course, yesterday was March the 2nd, where the Supreme Court had adjourned the ruling to review the March 3. And today, being March 3, the Supreme Court is set to deliver a judgment. Well, it's a lot of anticipation between now and 3 p.m. today. But we have joining us for more perspective and implication as to the ruling today, a legal practitioner, Mr. Awonuga. I would like to thank you for joining us on the program.
Thank you for having me. Good afternoon.
All right. So It's been a while we had you here talk about this. And we've also come a long way from the journey of last year to this point today. But what have you observed so far? Let's look at the process now, talking about the timelines from when it went sour for the PDP candidates and then when they approached the court to review the judgment and to this point where they're going to deliver the judgment.
Yes, regrettably, I think people have just been emotional about this. But lawyers who have taken their time to study the judgment of the Supreme Court would all be in agreement that the judgment was in order. Because just like law is an art, there's also a science. Now, there are rules for litigation. Otherwise, there will never be an end to litigation. It's not enough for you to have something, you keep it in your war chest. Up to the last minute, the matter goes to the Supreme Court. You don't tender it or you fail to do what you have to do. Now, let's center this particular appeal. What is the crux? The crux had to do with the units which Senator Uzodinma claimed were unlawfully excluded. And the law has been settled since the case of David Mack versus Abubakar Usman and also Doman INEC that no collation officer has the power to exclude any result once it is lawfully signed by a presiding officer of a unit. Only the courts can do that. Now, if you look at these results, what is the grouse of Senator Uzodinma? He claimed that from about 388 units, these results, they were properly signed and endorsed by presiding officers, but the collation officers, for reasons best known to them, they refused to entertain them. And unfortunately, the court below, referring to the Court of Appeal, sustained that. But the Supreme Court was saying, no, we have rules for these things. No matter how good or bad the argument is, no collation officer has the power in law to exclude a result once it has been properly endorsed by presiding officer. Only the courts can do that. And that's why I give you that case, the case of Senator David Mack versus Abubakar Usman and Doman INEC. And now, the other side, Emeka Ihedioha, they were contending that, oh, these results, they are fraudulent, they are this, they are that. But in the absence of a cross petition You can't competently raise that in law. The lawyers involved, after the ruling, sadly, they will have realized that, but it's too little, too late. They can't go back. Because once the court has given its ruling, you can't go, my lords, we forgot that we should have done a cross petition. Because the rule is there, the case of NJC versus Right Honorable Justice Aladejano, where the Court of Appeal mentioned that it is a plaintiff or a claimant that determines the issues at stake. If I take you to court and I say, for instance, this man, he engages in stealing chicken and all that, you can't go to court on the same place and say, oh no, this man is into bunkering, he's a kidnapper. There are different things. You have to have a counterclaim for that. The same way, to the extent that they failed to have a cross petition, despite all the things they raised, they were not competently raised there, because the court will say they are not known to law. Because in the petition of Senator Ozodimma, what he merely said was, my votes were unlawfully excluded. So the issue before the court was to determine whether these votes were lawfully excluded or not.
So finally, tell us the argument of the 60 days.
Yes.
The camp of Hope Uzodimma is saying that it is a lapse. Since a lapse, this is statute-bad discussion, merely an academic exercise.
You see, I don't want to preempt their lordships on that. What I'm discussing today is the ruling that has been done. We are looking at the judgment, whether from the angle of an ordinary lawyer, the judgment is sustainable in law. The issue of 60 days, I will want the court to be the final arbiter on that today. We're not allowed to do that while the matter is there before the court. It is sub judice. But the important thing, like I said, the issue of a cross petition. If you look at the Electoral Act under Section 380, before the camp of Right Honorable Ikeria could have validly raised these things, they must have a cross petition. It's in the cross petition that they are legally allowed to ventilate their grievances. In the absence of that, anything they might have said, whether it's true or not, votes actually, the votes made, outnumbered, the votes tallied and all that. The judges were not there.
All right.
So it's what you present before them that they are able to educate on. The central thing that they wanted to anchor on was that no collation officer has the power to exclude votes. It's only the courts that can do that. And regrettably, to the extent that the Court of Appeal sustained that, these votes were unlawful, that's why the Supreme Court overruled the Court of Appeal.
We'll wait until 3 p.m. We'd like to thank you, Mr. Awonuga, for joining us at this time.
Thank you.